Hello and welcome. This webinar forms part of a series of webinars given by Mayer Brown's Global Employment and Benefits Group on the issues affecting employers who are planning a return to work or who are adjusting to carry on business in the current circumstances. It forms a part of Mayer Brown's 1000 series, providing guidance into the top 10 pivotal issues across various topics that businesses need to be mindful of in the first 100 days of returning to work. Mayer Brown's global COVID-19 response offers insight on and analysis of the virus's impact on business worldwide through the dedicated portal known as Responding to COVID-19, which can be accessed via the Mayer Brown website or by searching covid19.mayerbrown.com. We have designed the webinars so that they can function equally well as either an audio-only broadcast or accessed via a video link. We hope you enjoy the series.
Good morning and good afternoon to everyone. Welcome to the UK Employment Law Perspective webinar that forms part of our Global Back to Business broadcast series. My name is Nicholas Robertson. I'm a partner in Mayer Brown's Employment and Benefits practice. I'm joined by my colleagues and partners, Fisher and Miriam Bruce, and together we will address key issues and risks that employers are grappling with on getting back to business. We held a webinar for multinational employers in May, which discussed the employment benefits and mobility issues and risks at a global level, in particular highlighting Brazil, France, Germany, Hong Kong, the UK and the US. You can access this global webinar via the Mayer Brown COVID-19 portal called Responding to COVID-19, which is available through the Mayer Brown website or by searching covid19.mayerbrown.com. This UK-specific webinar will now drill down into the detail. We'll highlight the legal framework for the key risk areas in the UK, and you'll see those in front of you on the slide 1 to 10. We'll also discuss how employers should navigate those issues when planning a return to the office. The webinar is part of our 1000 series, focusing on the top 10 issues that employers need to consider in the next 100 days. You can access the other national webinars in this series over the coming months, covering, we've got Brazil, we've got France, Germany, Hong Kong, we've got UK pensions, UK employment, so US employment, US benefits, global mobility. And those can be found via the Mayer Brown Responding to COVID-19 portal as well. And again, the covid19.mayerbrown.com site. So, on that note, let's get started. So, health and safety and risk assessments. I've got the task of outlining the statutory, regulatory and legal regime that is applicable, setting the risks for employers. And then Chris and Miriam, in reverse order, Miriam and Chris, in fact, are going to be talking about some of the practical applications and things to do, bearing in mind the risk framework, the regulatory framework that I'm going to be talking about. So let's start with the basics. The Health and Safety at Work Act 1974 and the Management of Health and Safety at Work Regulations 1999 set out statutory obligations that employers owe to employees. The Act, where it sets out general duties, and the regulations are more explicit in respect to what employers are required to do to manage health and safety. Under the regulations, employers are required to carry out risk assessments in relation to employees' health, have in place clear emergency procedures policy should there be an event that results in serious and imminent danger to persons at work. Employers need to communicate relevant information about the emergency procedures to all employees and provide appropriate training to ensure that those procedures have been properly understood. Now, it's easy to see how all of this has an application in the times which we're living in, especially in the context of a return to work. Secondly, employers have a statutory duty to consult with employees on matters concerning health and safety at work. Depending on the circumstances, that may be an obligation to consult under the Safety Representatives and Safety Committee regulations, where the employer recognises a trade union and health and safety representatives are appointed by the union, or it may be the Health and Safety Consultation with Employees regulations, which apply where there's no recognised union. The employer needs to consult its employees in good time, or the union, in good time on matters relating to health and safety at work, and in particular, there's a number of specific matters identified, including the introduction of any measures at the workplace which may substantially affect the health and safety of employees, and that's Regulation 3. Each of the COVID-19 secure guidelines put out by the government states that employers have a duty to consult employees on health and safety, and more particularly that employers will need to carry out COVID-19 risk assessments in consultation with workers or trade unions to establish what guidelines and safety rules to put in place. Employers with more than 50 staff are required to publish the results of their risk assessments on their websites for all to see, and employers with fewer than 50 staff don't get a free pass. They are encouraged to post their risk assessments onto the website. Employers' common law and contractual duties of care are also relevant. Obviously, employers have a duty of care towards employees to take reasonable steps to prevent foreseeable harm occurring to the employees. What constitutes reasonable steps will always be a question of fact dependent on the particular circumstances, but there are three key factors which generally apply to determine the standard of care owed by the employer. What's the standard of the reasonable company? The balance between costs and benefits of taking precautions, and common practice and expectations. While the government's COVID secure guidelines are not strictly legally binding, they are going to be very important, we think, in determining the standard of care owed by employers. And where employers have closely adhered to those guidelines, it's going to be much more difficult for a court to conclude or an employee to persuade a court there's been a breach of the standard of care owed to employees. Obviously, as well, the employer's duty of care forms part of the implied terms of employment contract and can be relied upon for a breach of contract, constructive dismissal claim, etc. Don't forget, of course, there are enhanced health and safety duties towards pregnant and disabled employees. This is, in the case of pregnant women, this is particularly relevant since current thinking is that pregnant women may be more at risk from the virus, and similarly, some disabled staff, asthmatics, diabetics, and so on, are more at risk. Remember, pregnant workers are entitled to a risk assessment at work under Regulation 16 if there is a potential risk to health and safety for mother or baby. And we think that would potentially apply to the risk of infection from the coronavirus too. So that's something an employer needs to take into account. Bear in mind too, there's current medical evidence suggesting there's an increase of risk of COVID infection to those of certain ethnicities. In its report on the disparities in the risks of COVID-19, Public Health England concluded the pandemic has replicated, in some cases increased, existing health inequalities. People of Bangladeshi ethnicity had twice the risk of death from COVID-19 than people of white British ethnicity. People of Chinese, Indian, Pakistani, etc. origin have between 10 and 50% higher risk of death compared to white British people. The Office for National Statistics report on 7th May 2020 showed an even more significant disparate impact relating to deaths by ethnic group. In particular, its analysis found that black males were 4.2 times more likely and black females 4.3 times more likely to die from a COVID-19 related infection than white ethnicity males and females. From an employment law perspective, employers may also need to consider this issue as part of a risk assessment for return to work and to think about these factors. And this melds with obligations under the Equality Act 2010. Failure to take appropriate steps to protect employees at higher risk on grounds of ethnicity could amount to indirect race discrimination, for example. What about commuting to work and employers' duty of care? Well, employers' health and safety duties do not include explicit statutory legal responsibility for an employee's journey to the workplace. Health and safety legislation focuses inevitably on the risk which employees may be exposed to at work, not the risks travelling to and from. The government guidance notes do say that employers should stagger arrival and departure times to reduce crowding into and out of the workplace and provide facilities for alternative ways of travelling where appropriate, maybe by cycling, for example. That's really as far as the guidance goes. But in certain circumstances, it's important to recognise that employees have a statutory employment right not to attend workplace if they have a reasonable belief that they're in serious and imminent danger. And of course, this is particularly the issue with those employees who are facing the prospect of returning to work, but only if they are going to use public transport in all its manifest joys. Section 44 of the Employment Rights Act is relevant here because if there is a serious and imminent danger, the employee reasonably believes the danger to be serious and imminent, and the employee takes appropriate steps to protect him or herself or other persons from the danger, or the employee is left and remained away from work because there were no appropriate steps he or she could take, which would have been expected to avert the danger. Well, in that case, the employee is protected from any adverse action taken by the employer, stopping pay, disciplining, final written warning, whatever it is. The employee is protected from any adverse action, and if any adverse action is taken where the employee reasonably believes the danger to be serious and imminent and has taken appropriate steps, well, in those cases, in those circumstances, well, the employer is staring down the barrel of potentially quite a significant claim. Health and safety executive can take enforcement action against employers for breach of health and safety obligations. There may be criminal sanctions, fines, imprisonment, or enforcement notices. Each of the COVID-19 secure guidelines notes that the HSE may take enforcement action against employers who are not complying with the relevant legislation and guidance to control public health risks. But, in practical terms, the historic risks for prosecution, well, historically, they've been pretty low. Fewer than 400 prosecutions occurred across Great Britain for the last year we have records, only 11,000 enforcement notices. But of course, we think that if an employer catches public attention for an infection spike, then I wouldn't bet against there being pressure for a show trial of sorts, so the authorities can be seen to do something to uphold health and safety rights. I mentioned the potential for an unlimited damages claim already, but it is an important point, so I'll go into it in just a little more detail. Obviously, the employee can sue for damages if there's a personal injury arising from the infection, although you'd hope that the risk of serious and lasting damage, even where an employee can prove they got infected at work, well, you hope that is, especially remote, that's going to be a low-risk outcome. But the things I would worry about far more as an employer are the risk of what I call ancillary damages claims, but they're uncapped. For example, in the context of an employee who refuses to return to work due to health and safety concerns about using public transport, if the employee is covered by Section 44, then any detriment, suspension, reduction in pay and so on, is a breach of legislation, gives rise to a potentially unlimited damages claim. It is easy to see that similar claims could arise under the disability legislation if people are exposed to greater risk and the employer isn't making reasonable adjustments. So the health and safety framework is actually a critical starting point here for employers looking to understand the right steps to take. So, next slide. Privacy issues. Let's talk about workplace testing, screening, compliance with GDPR generally. Health information about an individual, an employee's special category personal data, and an employer can only process such data on appropriate grounds under the GDPR. The ICO has also published information on its approach during the pandemic and has confirmed that as long as there is good reason for doing so, employers should be able to carry out health testing on employees, as data protection law does not prevent them from taking necessary steps to keep employees and the public safe during the pandemic. However, employers must handle employees' personal data with care. Now, one of the key relevant permitted grounds for processing special category data is processing it for health purposes. The ICO considers that an employer can process employee special category data as being necessary to carry out obligations and exercise specific rights of the employer or employee in the field of employment. And here, of course, that's going to focus on the employer's obligation to seek to take all reasonable steps to protect the employees and the colleagues' health and safety at work. Certainly, my take, and maybe this is a little simplistic, but my take is that the gist of the guidance from the ICO is that sensible processing of personal data is not going to be challenged by them if they can help it. Test and trace. The NHS test and trace, or whatever application we're now using for test and trace, I'm not going to say much about that, given the, well, I think it's fair to say, pretty much total disarray of the system. The key point, of course, is that employers must not be frustrating the scheme if one of their employees is contacted and told that they've come into contact with someone with infection, and so they are no longer able to come into the workplace. ICO guidance, well, the ICO have published a coronavirus recovery, which data protection advice for organisations. This confirms testing employees is permissible within certain prescribed parameters, but in order to show that it's been compliant, employers must have regard to the accountability principle, and the starting point for that is going to be doing a data protection impact assessment under Article 35 of the GDPR in deciding what employers want to do. In the ICO's guidance on testing, employers are reminded not to collect unnecessary or excessive information. For example, it considers that employers will probably only require information about test results rather than details of any underlying conditions if they're running tests. Employers should consider the testing options available, taking due account of what tests are necessary for fulfilling its health and safety obligations as an employer, as part and parcel of the measures being taken by the employer in response to COVID-19. Employers will also have to consider how these measures will meet their intended purpose of keeping the workplace safe, and how effective these measures are at providing accurate results, and further ensuring they're only collecting results that are necessary and proportionate. In the context of testing involving physical contact with the employee, swab tests, fingerprint tests, and so on, the guidance is that employers should inform staff about what personal data is required, what it will be used for, who it will be shared with, how long it can be kept for, and what decisions will be made based on the test results. All sensible stuff. In general terms, consent to processing is unlikely to be a sufficient ground from a data protection perspective, given the imbalance in the relationship between employer and employee. But consent is going to be required to administer any physical testing, taking temperatures, etc., swab tests and so on. Because if you went ahead without consent, that would potentially be a breach of contract, and probably be common law assault as well in relation to any individual. So there will be a role for consent, but don't confuse consent to being tested with consent to processing the data, where I think employers will be on far shaky ground. In relation to surveillance and monitoring, again, necessary to consider whether it's appropriate for employers to carry out temperature checks through surveillance and monitoring. The ICO guidance states that employers should give specific thought to the purpose and context of that sort of monitoring and temperature testing through that, and will need to be able to make a case for carrying out such testing or monitoring. Employers need to consider, can they get the same or indeed better results through less privacy intrusive means, and if so, then the monitoring may not be considered appropriate, and therefore it would be in breach of the legislation. Section 43B1 of the Employment Rights Act deals with whistleblowing issues, and that's what I want to talk about now. That section states that any disclosure of information which, in the reasonable belief of the worker making the disclosure, is made in the public interest and tends to show one or more of the following. I'd like to go through. These are going to be relevant to the context of the coronavirus. Well, one, a criminal offence is being committed, or is likely to be committed. Two, person has failed, is failing, or is likely to fail to comply with any legal obligation to which he is subject. Three, the health or safety of any individual has been or is likely to be endangered. And for the information tending to show any matter falling with any one of the examples I've given is likely to be deliberately concealed. Now, again, it's blindingly obvious in the context of coronavirus how any of those particular whistleblowing exceptions, whistleblowing protections, call them that, could be engaged. Now, to gain legal protection as a whistleblower, a worker must show that they've made a qualifying disclosure, i.e. disclosure of information that in the reasonable belief of the worker is made in the public interest and tends to show one of those relevant failures has occurred, is occurring, or is likely to occur. The employee is protected from dismissal or any other detriment under Section 47B, right not to be subjected to a detriment. Section 103A, dismissal is automatically unfair if the reason or principal reason for the dismissal is the employee's protected disclosure, or Section 105, which deals with being selected for redundancy on one of those prohibited grounds. And that, of course, becomes pretty relevant when you consider there may be plenty of redundancy terminations happening imminently. And so you could well see that statutory section being engaged with people saying, I was made redundant because I blew the whistle. It also means it's even more important to ensure that employers' redundancy policies are clearly thought through, well communicated, and have a rational basis. Now, my personal tip as well is that I think we're likely to see a lot of employees asserting that breach of the furlough rules have happened, and that i.e. that they or their colleagues were made to undertake duties on furlough. They raised this as a matter of concern, and they're now being punished for it, either by being dismissed, shunted sideways, made redundant, etc. And I saw a survey that was published this morning, in fact, that claimed that on a survey of a couple of thousand employees, something like 1/3 of them claimed they'd been asked to undertake or required to undertake work by their employer whilst on furlough. And of course, the whistleblowing provisions wouldn't just apply to the furloughed employees themselves, they'd apply to any employee who said, to an employer, you made these furloughed employees work, and that's a breach of the legislation. The other thing is that Protect, which is a whistleblowing charity in the UK, has reported there's been an increase in the number of calls to its advice line with employees blowing the whistle on employers abusing the furlough scheme. And we've seen reports in the media that more than 170 care workers have called the whistleblowing helpline since the coronavirus started, complaining about lack of PPE and inadequate health and safety standards. So I really do think the whistleblowing legislation is going to be front and centre of a lot of people's thinking in the near future. In addition to health and safety provisions, the Employment Rights Act contains specific provisions for health and safety activities. I've mentioned Section 44 and Section 100 already, but just to reiterate, because I think it's very important, the worker or employee reasonably believes there's serious and imminent danger which he could not reasonably have been expected to avert, and in those circumstances they left or proposed to leave, or while the danger persisted, refused to return to their place of work, or in circumstances of danger the employee reasonably believed, which was the employee reasonably believed to be serious and imminent, the employee took or proposed to take appropriate steps to protect themselves or other persons from the danger, or in those circumstances the employee cannot have a detriment imposed on them. And obviously, in the context of an organised return to work, something that is more than purely voluntary, the employer's desire to have a managed return to work and the employee's desire potentially not to have to travel into an infected environment or travel on public transport, well, those perfectly reasonable desires on both sides are going to be in conflict. And as in addition to the fact that there are uncapped damages, and you can imagine the tribunal will be pretty sympathetic to an employee if it finds that Section 44 or Section 100 is engaged. You've also got the employee relations, public relations nightmare, which would follow if there was anything like that found to have happened, that people raised concerns and were made to pay the penalty for it. So, on to my last slide, which is to do with discrimination. Employers obviously are under a legal obligation to ensure that decisions they make in response to COVID-19 don't direct or indirect discriminate against employees with protected characteristics. The EHRC have issued COVID guidance for employers on how to avoid discrimination. And the guidance sets out examples of instances of discrimination, such as manager asking female employees working from home to check in with him more than a male employee, because of an assumption that women with caring responsibilities are more likely to be taken up with those responsibilities than working. Or the employer deciding it won't recruit candidates from an ethnic minority to frontline roles, given the increased risks faced by ethnic minorities potentially from the virus. Or employees over 60 not being permitted to go back into work, again, because there's concerns about their health, and as such, the employer should be taking reasonable steps to deal with those concerns rather than banning a segment of the workforce. The guidance as well looks at disabled employees, and disabled employees shouldn't be treated adversely for reasons connected with their disability. It gives a couple of examples in that. For example, an employee's been off work for a period and is now shielding, and the employer is looking to shed labour and picks on them because they've been away from work for a long period of time. Sadly, and in this context as well, I think employers also need to be aware about workplace racism and xenophobia, which there are reports that it's been on the increase in the UK since the outbreak of the coronavirus. For example, a number of Chinese and Asian nationals have been subjected apparently to racist and xenophobic behaviour. Even more sadly, there seems to be potentially part of a rise in such behaviour following Brexit and so on. And employers do need to be aware that it's specifically in the context of coronavirus, but more generally, people seem more willing to voice more unpleasant opinions, and employers' duties towards minorities, and in this context, given some of the ludicrous conspiracy theories towards Chinese and Asian nationals, employers need to clamp down hard on any suggestion that there is any adverse workplace behaviour going on those grounds. Because it goes without saying that the PR and ER consequences of that sort of thing are just horrendous, as well as being unlimited damages. So that's a cheery note to end my section on. My apologies for that, but if I get asked to do the legal and regulatory framework, that's where you end up. So I'm now going to hand over to Miriam to take this webinar forward.
Thanks, Nick. The remainder of the webinar today will focus on practical steps we think employers should be considering given the legal framework which has just been outlined. I'm going to look at the first three topics before handing over to Chris. I'm going to focus on reopening the workplace, communication strategy and individual employee issues. But first off, then focusing on reopening the workplace, a topic which I'm sure many of you have already spent considerable time thinking about. As we'll come on to discuss, our view is that employee engagement and a good communication strategy are key to a successful return to work. However, in order for that strategy to be compelling, employers will need to ensure that first and foremost they're taking all reasonable care to keep employees safe. So what practical steps should an employer be taking now to achieve this in the current climate? The first practical starting point, of course, will be to ensure that in formulating your plans for reopening the office, you're familiar with and take account of the government guidance. As at the 24th of June, there were 12 separate guidance notes available to employers to access online about reopening the workplace in a safe manner. This included a general guide setting out 5 steps all employers needed to take to get people back to work, regardless of the sector. And then there are sector-specific guidance covering a wide range of workplaces, from construction to labs and research facilities and offices. It will be important to stay abreast of the developing guidance on an ongoing basis to ensure employee safety is at the heart of the return to work strategy. So the government guidance is a good starting point, but employers will need to do more to demonstrate that they've complied with their multifaceted statutory and common law duties regarding health and safety. At the most basic level, the practical impact of this is that the following steps will be required. First, the employers need to undertake a COVID risk assessment. And secondly, in light of the risks identified, employers need to identify the steps which should be implemented to manage those risks. And in light of the inescapable threat of a second wave, it will be crucial for employers not to see the implementation of its risk management strategy as a one-off job. On the contrary, this is an area which will require careful, close and ongoing monitoring to ensure that the employer is staying the right side of its statutory and common law duties. I'm shortly going to talk about the importance of employee communications. However, before doing that, I just want to spend a few minutes talking about practical points to consider when it comes to COVID risk assessments. Now, the risk assessment to be undertaken by each employer will of course be specific to their workplace. And the Health and Safety Executive have issued a lot of guidance to help employers through the risk assessment process. That guidance is clear that employers can't simply copy an example risk assessment and put their name to it. That won't be sufficient to meet the requirements of the law, nor to protect staff. Additionally, for businesses with fewer than 5 workers, the risk assessment doesn't actually need to be written down, although in our view it's certainly a sensible step to do that. The guidance also makes clear that the outcome of a risk assessment should be shared with the workforce, and goes on to state that all businesses with over 50 workers should publish the results on their website, although there's no legal obligation to publish on an external website. The Health and Safety Executive Guidance produced highlights and areas that should be considered in every workplace when carrying out risk assessments, and the guidance makes clear that the assessment should be fully comprehensive, covering all aspects of working life, from moving around the workplace to individual workstations, use of common areas, and handling items that come in and out of the workplace. It isn't possible to contract out of your health and safety risk assessment obligation. I have seen reference online to employers getting staff to sign up to waiver documents in respect of personal injury claims. But of course there are employee relations implications of getting staff to sign up to such documents. But in any case, there's little legal value in asking an employee to sign such a waiver, because various statutory provisions limit their effectiveness in the employment context. In particular, an employer can't exclude or restrict liability for death or personal injury. Once the risk assessment has been conducted, as mentioned, the next is to consider what steps can be taken to control or reduce the risks as far as possible. This could include a phased return, with people returning on a voluntary basis so as to reduce exposure to risk. It could also involve physically redesigning the workplace layout, providing protective equipment, and generally trying to reduce the volume of individuals on site. It will certainly involve considerations of how communal areas will operate, if at all, such as lift lobbies, canteens and staff rooms, and how objectively employers should select staff for return if that's what's required. And that's both to manage numbers appropriately and avoid discrimination risks. On the privacy side, government guidance does not include temperature testing or medical testing in the list of steps employers should necessarily be taking. However, reflecting the reality that many employers are actively considering these extra precautions, the ICO has released guidance on this issue, as Nick mentioned. The upshot being that workplace testing is possible in appropriate circumstances, but employers need to take sensible compliance steps first, including ensuring the testing is necessary and proportionate, being clear with staff about what will happen with the data once it's collected, carrying out a data protection impact assessment before testing starts, and ensuring that there's no less invasive alternatives such as people taking their own temperature, which would manage the risk. Employers aren't expected to eliminate all risks, but they do need to do everything reasonably practicable to protect their employees. For each workplace, this is a balancing act, taking into account the level of risk against what can be done to control that risk in terms of practicality, resource and time. And as I'm about to explain, the success of the balancing act will depend on how employers engage with their staff about such matters. Moving on to communication now, and in our view, the need to communicate effectively with staff is really at the heart of a successful return to work. Employers have a statutory duty to consult with staff over matters of health and safety, as Nick has mentioned, and clearly a return to work raises such issues. Employers may also be looking at other changes as a result of the pandemic, whether permanent pay cuts, headcount reductions, or enforced alterations to contracts. In these scenarios, a consultation process will be required, and most likely for any wholesale changes, there will have to be a collective consultation process with either a recognised trade union or elected employee reps. We think in general terms, employers should recognise that staff consultation is pretty much essential in these challenging times, and so having a staff forum will ease that process. A staff forum, of course, has a number of benefits for employers generally, not least in offering an effective route of communication to staff. There may be other benefits too. A staff committee signing off an unpopular decision may be worth its weight in gold to an employer in getting staff to accept the decision, but also in defending the employer against future legal challenge. We think that employers who do not have a standing body already should look at now setting one up. It can be a temporary body to deal with the challenges arising from the pandemic if the employer doesn't want to go the full way of setting up a permanent body. Even in these virtual working days, initial meetings can take place through technology. We're all now very used to working from home, but either way, the arrangements made to set it up should ensure that it could be used as a consultation body to discharge any statutory consultation duties that might arise, such as collective redundancy or TUPE transfers. A common question we've been asked in recent months is whether a furloughed employee could be a representative without breaking furlough. That was obviously a more relevant question prior to the implementation of flexible furlough, which applies from today, the 1st of July. However, our view is that even before flexible furlough, an employee could be a representative without breaking furlough. The HMRC guidance made clear that it did not regard duties and activities of employee representatives as work, as long as the representatives do not provide services to or generate revenue for or on behalf of the organisation. We think that a staff body should be treated by the employer as a valuable resource and invited to contribute comments and thoughts on the employer's plans. We also think that the employer will benefit too by adopting a genuinely collaborative approach. This will, for example, enable the employer to achieve buy-in where it is looking to alter working practices which may have gone unchanged for years. Equally, it will enable the employer to gather appropriate commentary on experiences and suggestions through the staff committee. One suggestion which we've seen is that staff should be surveyed shortly after their return to work or in the week leading up to it for their views on how the company has handled the working from home process, what could be done better, what worked well, and so on. A staff committee could be involved in reviewing the results of that for their input, and any output will be very, very valuable if there is a second wave. Equally, the communications programme directly to staff is vital. A staff forum can never be an alternative to such a programme. The employer will probably need to recognise that some communications will need to be company-wide, but others may need to be targeted to particular groups of employees. For example, the process of reintegrating furloughed staff is potentially going to be different from the process for reintegrating staff who were not furloughed. Staff who have been furloughed may well feel that they have limited prospects at the company on their return, and if the employer is looking to retain them, obviously they will need to pay additional attention to those members of staff to ensure they're feeling valued after the ending of their furlough period. And Chris is going to talk more about managing furlough staff shortly. Finally, just to bring it back to the health and safety issues I started off discussing, we think the employer should be very clear that it will be taking advice and considering respected sources on health and safety matters as it engages with its staff forum and workforce. With so much misinformation flying around about coronavirus, employees can easily get lost in that blizzard of information. There will no doubt be anxious days as we return to the workplace, especially in the initial stages of a return. See whether the virus is returning to pre-lockdown levels and how the magic R number is doing. But the employer can assure employees that it will be monitoring that position closely and making regular announcements as to how the return to work is going will help to demonstrate that health issues are of paramount importance. So moving on now to addressing employee issues. So far we've spoken about issues in general affecting employers. However, it's certainly the case that individual employees will be raising matters affecting them personally or which may affect a group of individuals. Of course, it's impossible to predict all of these issues or to discuss all of them now, but I'm just going to run through some which we think are likely to be raised in the very early days as plans to return progress. First off, what about employees who are concerned about returning to work either because of personal health reasons or because of the health of someone they live with or because they're concerned about travelling to and attending work and going on public transport? If the individual is not shielding, and we know shielding is obviously going to be paused from the 1st of August, and they're not themselves sick, then in normal circumstances it would be legitimate instruction to require these employees to attend work in line with their normal working schedule. However, as we all know, these are not normal circumstances, and employers will need to be measured in handling such issues given the potential claims which could arise through a heavy-handed approach. Of course, an employee's legal rights in these scenarios will be highly relevant and will determine how an employer should proceed. For example, an employer who has an individual who has underlying health conditions may find that it's under an obligation to make reasonable adjustments for that individual if they're disabled. If the individual wishes to work from home rather than travelling into the office, that may be viewed as a reasonable adjustment, particularly if it's for a relatively short term. An employee who cannot work from home but who is saying they're afraid to travel into work but who doesn't have an underlying health condition may need to be encouraged to be more realistic in due course, or the employer may wish to find an alternative role for them or consider, for example, a period of unpaid or lower paid leave for a short period until the position becomes clearer. Of course, we anticipate that most employers will wish to be reasonable. No employer is likely to wish to discipline or dismiss an employee for refusing to attend work in these circumstances, because that will create what could be a highly damaging claim, both legally and from an employee relations and PR perspective. On the other hand, employers may feel that at some point they have to draw a line in the sand and require individuals to come in, as otherwise any return to work might become disorganised. This leads me back to the communication point I mentioned in my previous slide, namely the importance of clear communication both with any collective body at work and with individual employees. I think this is particularly relevant in the context of fear over public transport. There can be no drawback for employers to discussing commuting plans, for example, with their health and safety committee or with its staff on an individual basis. advice can be taken from experts and reputable sources on steps that commuters could take to lessen the risks. The employer may be able to stagger start times, for example, to ensure that peak travel period times are avoided. It may be that through consultation with staff, the employer is able to come up with an acceptable approach, and that in the long run is far more likely to assist an employer in defending a claim if the need arises. And of course, any policy addressing commuting to or from work should presumably make clear what is expected from individuals who have an enhanced risk profile, underlying health condition, or perhaps pregnant, so that those staff are catered for too. But what about employers who have employees who say their childcare or elder care arrangements haven't yet resumed, and so they're unable to return to work? Clearly, as with the prior scenario, employers will want to be understanding, but there may well come a point when they have to draw the line. Identifying a policy now that indicates that individuals who have problems such as this will need to have a discussion with their manager at an early opportunity, but will be given extra time to resolve matters rather than the statutory two days might be appropriate. Obviously, an employer will be mindful that employees may simply require a period of parental leave if they have children who qualify under the scheme, in order to ensure that they can put appropriate alternative arrangements in place. In general terms, employers are probably going to have to get used to the challenges arising within the workforce, and in particular more vulnerable employees demanding a greater degree of protection to guard against the greater risks they face. Finally, one issue which we have already seen is whether an employer is obliged to tell employees if one of their colleagues has become ill, if they or one of their colleagues has become ill with the virus, and if so, what can they say? It's not an easy question, as the employer's obligation to take care of the health and safety of the workforce are likely to conflict with the desire of individuals not to have sensitive personal data disclosed to their colleagues. It may be that the solution is that individuals who are at risk of having been infected at work need to be given more information than those who simply work in the same premises. But we think the best way to address this is to discuss the issue with the staff forum now, and deal with it in the abstract ahead of time, rather than having to deal with it on an urgent basis when everyone is back to work. I'm now going to hand over to Chris to talk about the next topic.
Thanks, Miriam, and hello, everyone. I'm going to finish off the main sections of our webinar by discussing the final three of our top 10 issues. And these are how to manage furloughed staff, assessing headcount requirements, and then finally making changes to contracts and HR policies. So first of all, managing furloughed staff. Before March of this year, I don't think I'd ever used the word furlough. Now it's a verb, it's a noun, it's an adjective. We love it. I use it all the time. The government furlough scheme, which was announced in March and began in April, has been heralded as one of the most generous government subsidy schemes anywhere in the world, I think. At the moment, the last figures show there are around 9 million employees who have been furloughed at a cost of about £20 billion. And the scheme has been extended most recently to the 31st of October, but the government has made clear that it will end on that date. But there are two reasons why we think employers might be considering now about bringing employees back from furlough. The first is the recent introduction of flexible furlough, and secondly, the fact that the scheme is not only ending, but before then it's becoming significantly less generous. So in the time we have today, I won't go into detail on all the issues related to furlough, but I did want to pick out 3 points on the recent changes to the scheme. And those are flexible furlough, the new rules on who's eligible, and the new requirements for the employer going forward to pay part of the furlough subsidy. So firstly, flexible furlough. From the 1st of July, the employer and the employee can agree a part-time working arrangement and still claim a furlough subsidy for the time when they're not working. Now, the employer is responsible for the employee's pay, which will be their normal pay, during the time that they work. And then the furlough subsidy that they will be able to claim during the non-working portion will be reduced, which I'll talk about in a moment. In addition, there will no longer be any requirement for a minimum 3-week furlough period. So rotations on and off furlough can be made much more frequently than currently. So at first glance, flexible furlough would appear quite an attractive option for employers who are looking to get staff back to work on a phased basis, and perhaps where those staff may have concerns, as Miriam has mentioned, about suddenly returning full-time. But there are a couple of points in particular to bear in mind. First, the part-time working arrangement must be agreed with the employee, and that agreement must be confirmed in writing. Now, this is a contrast with normal full-time furlough, where the government guidance eventually made clear that the consent of the employee to being furloughed was not required. So an employer can instruct an employee to go on full-time furlough. Now, you could argue that an employer could instruct an employee to go on flexible furlough and record that in writing and then imply an agreement if they then turn up under the new arrangement. But we think this is risky, and it's much more likely employers will look for explicit agreement with employees that they're looking to put onto flexible furlough, particularly where the validity of their furlough claims might be jeopardized if they didn't do that. The second and probably more significant point, though, is that the furlough subsidy available becomes much less generous where flexible furlough is used. And without going into the horribly complicated calculations that have to be run where flexible furlough is being used, the basic point is that the subsidy that can be claimed for the time spent on furlough will reduce proportionately to the time spent working. So to give you a very basic example, for an employee who works half of their normal working time and is furloughed for the other half, the maximum amount that the employer can recover for the furloughed part is going to be reduced by 50%. So the new maximum, the new cap that will apply to the furlough claim will be £1,250 instead of the current £2,500. So whatever type of furlough agreement you have with your employees at the moment, it makes flexible furlough significantly less attractive. And there are two possibilities. Either you will have agreed with the employee that their pay is reduced to the government subsidy level, in which case it's less attractive for them to work flexibly because that subsidy is being reduced, or you'll be paying an employee's full pay during furlough and just recovering as much as you can under the scheme, in which case as that subsidy drops, so flexible furlough becomes less attractive for you as the employer. So that's flexible furlough. The second point I wanted to mention are the new rules on who is eligible for furlough. And there are two aspects to this. First, from the 1st of July, the scheme is only going to be available to staff who have been furloughed before. Now, given the rule prior to the 1st of July that furlough had to be for a minimum 3-week period, there was a concern that the scheme going forward was only going to be available to those who had been furloughed immediately before the 1st of July, i.e. for the 3-week period from the 10th of June. But the latest guidance has confirmed that the scheme will apply to employees provided they have been furloughed at any time prior to the 1st of July. And the other aspect is a rule that from the 1st of July, employers will not be able to claim for more employees than they have claimed for in any prior month. So to give you an example, as the guidance note does, if an employer had submitted monthly furlough claims for 30, 20 and 50 employees in each of April, May and June, the maximum number of employees that can be included in a monthly furlough claim after the 1st of July will be 50, the previous maximum. And finally, my third point to mention is the gradual requirement for the employer to start paying part of the furlough subsidy. And this is going to come in stages. So currently, the government subsidy pays up to 80% of the employee's pay, capped at a maximum of £2,500, plus employers' national insurance, plus the auto-enrollment pension contributions. Now that is going to step down as follows. First of all, from the 1st of August, the employer will have to start paying the national insurance and pension contributions. And then from the 1st of September, the salary subsidy paid by the government will drop to 70% of pay, and the cap proportionately would drop to £2,187.50. And from 1st of October, it will drop further to 60%, and the cap will drop to £1,875. And that 10 and 20% shortfall in each of those months will have to be picked up and paid by the employer, so the employee is still receiving the full 80%. So that's furlough. All in all, I don't think anyone is surprised the government is stepping down the generosity of the scheme, and introducing flexible furlough no doubt has its benefits, and it's clearly intended to encourage employers to start bringing more employees back on a gradual basis. But on the other hand, flexible furlough is very complicated, and it's significantly less generous than maintaining an employee on full furlough. So when you add that to the fact that you need a written agreement with the employees in question, I think flexible furlough may not be as widely taken up as might otherwise have been the case. So moving on from furlough, but very much related to it, is the question of staffing requirements. Now, if, as is likely in many cases, the furlough scheme is what has delayed employers from moving ahead with headcount reductions, the fact we now know it's coming to an end, and when it's coming to an end, is going to bring this back into focus. Now, given the numbers of employees who have been furloughed that I mentioned before, it's more than likely, unfortunately, that these redundancy exercises are not just going to be individual one-on-one exercises, but they're going to be collective redundancy programs. Now, as many of you know, the test in the UK is that collective consultation obligations are triggered when 20 or more redundancies are proposed at the same establishment within a 90-day period. And where that's the case, there'll be a minimum 30 or 45-day waiting period from the start of collective consultation until the first dismissal can take effect. So given how soon the furlough scheme is going to start ramping down, which, as I mentioned, is going to be from the 1st of August, employers who think that they need to make redundancies once that point is reached are going to need to be starting their collective processes now if they want to complete them while the furlough scheme is still running, albeit in a less generous form. Just pausing there, one common concern that we've seen from clients is the question of whether the furlough scheme even allows a redundancy process to be begun for employees who are on furlough, or for anyone while there's a furlough scheme out there still available, given there's a scheme there whose purpose it is to retain jobs, not to make people redundant. And there have been some criticism publicly of some large organisations who have run recontracting and redundancy exercises during the furlough scheme, but there's nothing in the scheme, either in the Treasury directions or the guidance notes, that prohibits redundancy programs starting while the furlough scheme is still running, or indeed from including furloughed staff. And although redundancy payments can't be subsidised by the scheme, the salary during the consultation period and any subsequent notice period can be claimed. So there are obvious practical challenges to running a collective consultation process where you've got employees who are largely working remotely or indeed furloughed. And again, without going through all of those today, I wanted to mention a couple of key issues based on our experience of working with clients on these sorts of exercises over the last couple of months. And the first one is employee representatives, which is really the fundamental aspect of collective consultation as opposed to individual consultation. And really the issue is how quickly can you identify who your employee representatives are going to be, because that can really affect how long the collective process is going to take. Now, if you have a trade union that represents the affected part of the workforce, or an elected employee body whose remit includes collective redundancy consultation, then the need to elect employee representatives might be avoided altogether. But otherwise, some form of election process is going to need to take place. And the key in any such exercise is to make sure that all of the affected employees are represented and have had the opportunity to vote, including any staff who are on furlough. They should have the opportunity as well to stand as a representative not just to be represented in the consultation. And as Miriam mentioned before, one of the early queries under the scheme, under the furlough scheme, was whether employees on furlough could perform the role of an employee representative, or whether that would constitute work and so would invalidate the furlough claim. But as Miriam said, the guidance has since made it very clear that that's not the case, and furloughed employees can act as employee representatives. So once you've identified where you need to appoint representatives, it's then the issue of actually communicating with the employees who are remote that becomes the real challenge, both in terms of electing the representatives and then after that carrying out the consultation itself. Where employees have access to IT equipment, then email and video conferencing will obviously make things much easier. And in a recent exercise we worked on, our client undertook a very large consultation exercise which ran very smoothly, due mainly to the significant forward planning they undertook. They used video conferencing very widely and very successfully, but they also followed up everything assiduously with emails, and they were very organized about linking into the representatives and helping them provide the employees they represented with whatever information they needed, and they made sure it was a very transparent process. Now, granted, they had a very organized HR team and an HR lead coordinating it who was very experienced, and one thing they also did, though, was not just to leave it to the HR team, but they made sure that their CEO was the one who was seen to be leading the process, and he was the one very visible on every call, on every meeting, and on every documentation, on every document that went out. And that, I think, helped the process very much. There was very much a top-down approach to it. So I think there are really two key messages to take away with collective consultation. First, start early. Plan ahead, and don't think that the furlough scheme prevents a process from starting. And secondly, do the best you can. I doubt any collective redundancy exercise is going to be perfect. It never is normally, to be honest, but certainly in the current environment, it won't be. But any tribunal, if they were looking at it later on, is bound to take these exceptional circumstances that we're currently in into account. And just pausing on that point, it is worth mentioning that there is, as many of you will know, a special circumstances defence available under the UK collective redundancy law, which can relieve employers from liability where it's not reasonably practicable for them to comply with certain aspects of the collective consultation requirements. Now, I think it's unlikely that this would allow an employer to say that it couldn't do any form of collective consultation, but it may help them where there are technical breaches along the way in their process, perhaps regarding communications with staff that they're able to do, provided, as I say, they have done as much as they reasonably can. And finally, just before I finish on this section, where a collective consultation exercise is necessary, always remember that there will still be a need to carry out individual redundancy consultation in addition. So that needs to be factored into your timetable. Now, one of the advantages of having done a collective process is that the subsequent individual consultation which follows should be easier, and that's certainly been our experience when we've helped clients with those exercises. And although many of the same practical issues will exist, one-to-one communication should be more straightforward, albeit logistically challenging still for managers and HR teams having to resource such a process. Okay, and finally, in at number 10, it's number 10 of our top 10 issues, which we've entitled Reimagining the Workplace, but really what I want to talk about is, as part of that, changing employment contracts and HR policies. Outside of headcount reduction, there are various other changes that employers are likely to consider for their employees as we move towards a return back to normal working, whatever that may be. And as I say, those could be changes to employment contracts, policies, or other operational changes to our general ways of working. Now, the approach to achieving these changes will depend at first on whether what you are changing is contractual or non-contractual. So looking first at contractual changes. An employer may want to change things like working hours, place of work, salary, benefits, holiday entitlements, or possibly, a number of our clients have looked at this, adding into a contract an express layoff clause, the right to lay off employees, looking ahead to a possible second lockdown. They're looking to include the ability to suspend staff so that if we get to that point, they can do it more quickly than when the first lockdown happened. So deciding on the best approach for introducing these sorts of changes will depend on which ones you're looking to introduce and how significant they are. But the normal rule with contractual changes is that employee consent is needed. Now that in itself can be a daunting prospect where you've got a large number of employees, although I think we've all seen in the last few months an increased willingness on the part of employees to accept what are pretty significant changes, detrimental changes to their employment terms in order to preserve their jobs. But despite that, can you actually rely on an employee not objecting instead of getting express consent? Possibly, but it leaves you in a very uncertain position because you won't know if later down the line those employees who haven't expressly consented to the change will claim breach of contract and it was done without their consent, or where it's a financial change like a salary reduction, that it was unlawful because it's a deduction from wages and you didn't get the necessary written consent to it. So to avoid that risk, the much safer route for introducing significant changes where employee consent may not be forthcoming is to carry out a recontracting exercise, which involves proposing the new terms to the employees and then conducting a collective consultation process. Now, the hope will be that as many as possible of that group will ultimately agree the changes, but for those who don't, they are then issued with notice of termination of their current contracts and offered the new terms in their place. Now, that sort of termination and rehire process is quite a daunting option for most employers, but it does deliver certainty because there is no breach of contract. Although, as I say, where you end up with 20 or more employees who won't agree to the changes, it will require the same collective consultation process as in a large-scale redundancy exercise, and so it's not something that can be achieved particularly quickly. So as with the redundancy exercises that I've talked about before, starting as soon as possible is really the key. So that's contractual changes, but what about non-contractual changes? Well, just dealing with very briefly, because I'm conscious of time, there will be numerous policies and procedures that employers will be reviewing to see where changes are going to be needed in the new normal way of working. And changes to policies like that should be easier to achieve because an employer can normally dictate its working arrangements and policies unilaterally. So the need for consent is not there, but communication with staff will still be key, as Miriam has talked about, so that the workforce understands what is being changed and why is it being changed. And finally, just to conclude, I think the really bold employers are going to be the ones looking beyond contracts and beyond policies into a complete reimagining of the workplace and really questioning the assumptions we have about how work should be done and the role of the office. And it will be interesting to see the extent to which the recent changes to our way of working will continue on a more permanent basis. Speaking personally, I feel very confident about the future. I have managed to work out how to share my screen on Microsoft Teams, and so if I can do that, then I think anything's possible. So that brings us to the end of our the formal section of our talk, our top 10 issues. I'm going to pause there and leave some time for any questions.
So this brings us to the end of the webinar. Thank you very much for joining us today. It's hugely appreciated. As I mentioned at the start, the webinar is part of our 1000 series, focusing on top 10 issues that employers need to consider in the next 100 days. You can access the other webinars in this series over the coming weeks. And we've got webinars relating to Brazil, Germany, France, Hong Kong, UK pensions, US benefits, global mobility, and that's all via the Mayor Brown Responding to COVID-19 portal on our website, or by searching covid19.mayorbrown.com. If you'd like similar information on another jurisdiction outside the ones I've named, let us know. Contact your usual Mayor Brown contact, or email our events team at lon-events@mayorbrown.com. That's lon-events@mayorbrown.com. We work with a well-established network of law firms throughout the world, and we'd be happy to explore doing a joint webinar if there's sufficient interest. So, thank you again for listening, and have a safe day.
Hello everyone, I hope that was useful and informative, and I'm delighted to say we've had a number of questions, and so probably the thing to do is to share them liberally around the speakers. And so I'm going to pick Chris. Do you want to take the question about whether your view on the furlough changes that have been introduced by the new scheme has altered at all with the publication of the Treasury Directive last Friday?
Yeah, sure. Thanks, Nick. I think the short answer is no, I don't think it has. I think the Treasury Direction is by and large consistent with what we'd heard before in the announcement and the guidance note. I think just two quick points to mention. Slightly concerningly, there is a statement in the new Treasury Direction that the purpose of the furlough scheme is that the amounts paid to employers under it are used by them to continue the employment of employees. And so just going back to a point I mentioned about employers being concerned as to whether or not they can make employees redundant and run down notice periods during a furlough period or while the scheme is still available. I think this goes to that and possibly, but I think it's more of a PR issue if people are looking to criticize an employer for doing this, because I don't think what the scheme says there means you can't do it. And certainly the guidance notes and the 19th June guidance notes explicitly says that you can make employees on furlough redundant. But just a slightly concerning comment, because that's not how the scheme had been described in the previous Treasury directions. And the other quick point just to mention is that, again, slightly bizarrely, the way the Treasury Direction describes people on furlough after the 1st of July is that everyone is flexibly furloughed. Everyone is a flexibly furloughed employee, whether they are furloughed all of their time or part of their time. And that has a knock-on effect that means the requirement for a written agreement now expressly applies to flexibly furloughed and full-time furloughed, whereas before I think we'd thought if it's full-time furlough, an employer can instruct an employee to go on full-time furlough. To be honest, I think we still think that's the case because it's a reasonable instruction to make. But if you want to be on the safe side going forward, I think you'd want written agreement and consent in place for both flexible and full-time furlough, given the way the Treasury Direction is drafted. But other than that, those are the 2 points to mention. Other than that, it is broadly consistent with what we were expecting.
Although a truly impenetrable read for anyone who has to wade through it. It is one of the most densely and badly drafted bits of legislation I've ever had to put up with. So good luck if anyone out there is going to work their way through it. Miriam, do we need to provide face masks as part of risk assessment findings?
Thanks. Yeah, it's been lots of questions on my section on risk assessments. This is an interesting one about face masks. Obviously, a lot of talk in the press about this. And in terms of the answer, it will depend on the findings of the risk assessment. As I said, if the risk can't be removed, employers need to consider mitigation steps. And obviously there's much talk about masks being a mitigation step, but it's important to remember, I think, that the government has made clear that mitigation should properly be implemented through social distancing, increased hygiene and so on, rather than the use of PPE such as face masks. And to protect the national supply, the government have advised against the precautionary use of PPE such as face masks. Of course, if your risk assessment shows it's necessary, if your operation isn't an office per se, I think you would need to provide it, but it's worth bearing in mind that government guidance against depleting the national stocks.
Yes. and face masks as opposed to face coverings or anything of that lesser nature.
Yes. And I think you'd have to support employees if they were wanting to use face coverings, or if they were providing it themselves, but not rely on that as your own risk management strategy.
Understood. Since you're boasting, Miriam, about having had more questions than any of us, do you want to do the next one, which is what are the implications for government workplace safety guidance?
Sure. Yeah. So a few implications to think through if an employer was to breach the government workplace guidance. Well, primarily you could face a claim from an employee that they've suffered an injury, personal injury as a result. Of course, they may claim they've contracted COVID-19 because of improper risk mitigation, but I think we might also see claims about mental health injuries, stress-related injuries, and so on. That's certainly something to watch out for. It's obviously an anxious time for everybody, and that's why, as I was talking in my section, employee communication will be clear to try and manage that risk. Of course, employees might refuse to come to work if they think an employer is not properly implementing the guidance, and there may be points to think about in terms of non-employees such as contractors and clients and so on coming into the workplace. In terms of sort of serious cases of breaching the guidance, it's worth obviously mentioning, as Nick alluded to, that employers could face criminal prosecution for breaching health and safety legislation if they fail to take reasonably practicable steps. Directors, managers and officers can also be found guilty of an offence if it's committed with their consent or attributable to neglect. Obviously, responsibility for prosecuting those offences is with the Health and Safety Executive, and they have issued some very helpful and easy to follow guidance about risk assessments and so on, so it's worth having a look at the website. And of course, generally there won't be a criminal prosecution unless there's clear evidence of a health and safety breach, which is called serious harm, and that there are public policy reasons to prosecute as well. So it'll be interesting to see how the Health and Safety Executive monitor employer compliance with this.
Yes, you can see it being an immensely political decision if there were prosecutions, but equally, maybe it wouldn't be that surprising to see one, just to make everyone aware that the authorities are out there looking after our health and safety. Fine. Okay. Well, I think there's one question left, which I'll pick up, about have we encountered any employers that have required employees to go back to the workplace and have met sort of significant resistance to that suggestion. I think we're in the early stages of seeing that, to be honest. I think that where there have been return to work programs, in many cases what we've been seeing is largely voluntary, as a way for gearing up towards a more compulsory return to work. But certainly there does, as a generalization, seem to be significant resistance amongst many employees to going back to work. And the trouble for an employer is there's going to be a whole range of things, from people who are legitimately worried about their own health or family health or of childcare reasons, all understandable, perfectly valid reasons. People who are worried about commuting, public transport is going to be the great conundrum, and how you make that safe for people. The people who simply go, I prefer to work at home, thank you very much, I've discovered I can do it and I'd like to keep doing it. And I think to the extent that return to work has got two elements to it. One is it safe? Can the employer make it safe? And secondly, can the employer encourage people back to work without having to wield the big stick? Because you'd certainly feel that if you have to wield the big stick to get people back to work, you're going to lose the battle, the sort of hearts and minds battle. It may be that the employer has to be relatively patient, if it can be, and encourage and coax people back to work, rather than going straight for, it's a legitimate instruction, now get back to work, because that's likely to produce pushback. So, I think that is all the questions. Just say thank you once again very much, everyone, for joining. We will be sending out the materials to everyone on this after the session. A copy of the recording, the materials, the slides that we've shown, together with the return to work checklist that we've produced, and which we hope will be useful. So, thank you very much, everyone, and have a safe day. Bye.
Thank you. Bye.
Bye, everyone.
Thank you for listening. We hope you found this useful. This series forms part of Mayor Brown's 1000 series, providing guidance into the top 10 pivotal issues across various topics that businesses need to be mindful of in the first 100 days of returning to work. If you have any questions, please get in touch with any of the speakers or your usual contact at Mayor Brown, and we will be happy to follow up with you directly. For the latest COVID-19 related legal developments, please do visit our dedicated portal called Responding to COVID-19, which is available through the Mayor Brown website.